Good evening, everyone, and welcome to the certificate course on Insolvency and Bankruptcy Laws. My name is Akshat Mittal, and today I'll be taking the module number 1, which is titled as Evolution of Insolvency and Bankruptcy Laws in India. We will be taking a journey through the development of insolvency and bankruptcy laws in India and how this Insolvency and Bankruptcy Code 2016 was ultimately enacted. So, before we start our journey, I would like to read out the preamble of this very code, because the preamble of this code, though very short, it gives a detailed features of what this insolvency and bankruptcy code entails, and it also gives us the clue that how these insolvency and bankruptcy laws has developed over the period of time. So, the preamble of this code goes like an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. So, when we read this preamble, we get to know that there are 4 to 5 features which every insolvency and bankruptcy law aims to achieve. Firstly, the objective of time-bound manner, that every proceeding, every insolvency proceeding, every liquidation proceeding should be in a time-bound manner. Secondly, the insolvency and or liquidation proceedings should be carried out in such a manner that it maximize the value of assets of such insolvent and bankrupt persons. Thirdly, to promote entrepreneurship, that is the development of overall market economy and to promote the idea of entrepreneurship. If a insolvency process or a liquidation process is carried out swiftly, then ultimately it adds to the benefit of an entrepreneur and it encourages the young entrepreneurs to come forward in the market and carry different kind of business, innovate in the market. Then availability of credit. Now, when we talk about startups in today's world, we all know that every startup, every business requires money. So availability of credit is a very important element in the insolvency and bankruptcy regime. Lastly, balance the interest of all the stakeholders. Now, in an organization, there are many stakeholders. As such, if we take a company is firstly having its promoters who has put in a lot of money to float that company. Then directors of the company who invest their time and money both in developing the business of the company. Then there are shareholders who invest in the company. Then there are creditors such as banks and also trade creditors who give raw material or let's say any other service to the company on credit basis. So the question is, how do we balance the interest of all the stakeholders when we are talking about an insolvency or a bankruptcy law? And these 4 to 5 ideas has always been there. And these 4 to 5 ideas are those basic ideas on the premise of which the insolvency and bankruptcy laws has developed over the period of time. So when we go to the pre-IBC era, there were few multiple remedies available to creditors. Firstly, the very basic remedy of approaching a civil court to file a recovery suit. So before we go into that, there's one more question which arises, that what do a creditor want from a company? So creditor lends money to a company. Now he wants to earn money, which he does in the shape of the interest. And ultimate goal of a creditor is to get back the money which he has lent to the company. Now, to get back that money, what all are the remedies available to a creditor? So, firstly, as we spoke of, he has a remedy of going to a civil court where he can file a simple money suit or recovery suit. Then we talk about RDDBFI Act, which was of 1992 and which established the DRT, 1993 Act, which established the DRTs. And under that Act, banks and financial institutions were given a special forum to approach for recovery of their money. Then later on, SARFAESI Act came into being, where the secured creditors were given an option to enforce their security interest, to take the possession of the security interest by themselves. And that's how these type of options were available before the Insolvency and Bankruptcy Code was enacted. Now, how these options were short in resolving an organization, that we will be seeing through our journey when we study the evolution of insolvency and bankruptcy laws in India. Now, coming to the first act, which is the Sikh Industrial Companies Act. It was enacted in the year 1985, and the preamble of this act makes it very clear that the scope of this act was limited to the industrial companies, which were time and again notified by the central government or which were prescribed in the schedule of the said act. So the preamble of this act goes like an act to make in public interest special provisions with a view to securing the timely detection of sick and potentially sick companies owning industrial undertakings, the speedy determination by a board, which is the board for industrial and financial reconstruction, established by this act itself, board of experts of the preventive, ameliorative, remedial, and other measures which need to be taken with respect to such companies, and the expeditious enforcement of the measures so determined and for matters connected therewith or incidental thereto. Now, this Sikh Industrial Companies Act was in itself a very unique legislation, because this legislation also focused on reviving an organization or reorganizing the assets and liabilities of an organization. And the purpose of this act was to ultimately save the business. Whereas when we talk about RDBFI Act or the SARFAESI legislation, the main purpose of those two legislation was to establish a speedy debt enforcement procedures for the creditors. So, Sikh Industrial Companies Act, RDDBFI Act, and SARFAESI legislation, all these three acts were prevalent before the IBC came into being. And there were many problems over and again which were being faced by the High Court, Supreme Court, DRT, civil courts, because there were many issues of overlapping jurisdiction. Which act shall prevail over which act? A creditor should approach which forum first, which forum second, and basically it was all in the open for a creditor. And there was no consolidated framework which could be followed. So, the idea of insolvency procedure is majorly to focus on the reorganizing a company or reorganizing a debtor for that matter, maybe partnership firm, individual. It is not the debt enforcement which an insolvency laws, which a good insolvency law aims at. It is the reviving of the business of that organization so that a business may go on. A company may be taken over by another company, but the business shall go on. And if the business is going on, the interest of this all the stakeholders are taken care of. So when we come to SICA. In SICA, there were the BFIR. It was it was under a duty to deal with the rescue and rehabilitation of a company. And how does BFIR takes up that job? So BFIR, to give you an idea, it was a board of experts in the field of banking, finance, and other management sectors. And the main purpose of this board to was to analyze the financial statements of that company, to study the audit or forensic audit of that company, and basically to give a judgment that whether this company can be revived or not, or whether the safest option is to liquidate the company. So this was the job of BFIR. Now let's say once the BFIR determines that the company uh, is that the company has to be liquidated because it cannot be reorganized in any manner so as to safeguard the interest of the creditors, so as to repay. There cannot be any repayment schedule which can be reached at to pay off the debts of the company. So once the BFIR gives the decision to liquidate the company, it refers the matter to the High Court, which then follows the winding up procedures as laid down in the Companies Act, that an official liquidator will be appointed, then the valuation of all those assets, and then auction proceedings will take on. And likewise, all those proceedings used to take a lot of time. Now, coming back to the Insolvency and Bankruptcy Code, when we read time-bound manner in the preamble. Why this time-bound manner is important when we are studying insolvency and bankruptcy laws? Time-bound manner becomes important because the assets, the value of those assets, they tend to deteriorate over the period of time. Now, we all know the basic concept of depreciation. So let's say a machinery or a plant is there and an industrial unit goes bankrupt. Now that industrial unit uh, is not carrying out any business operations. So ultimately, when a plant or a machinery is there, their value tends to depreciate over the period of time. And the more time is taken in litigation, the value is reducing day by day. Therefore, to keep the insolvency procedure in a time-bound manner becomes a very essential element, because ultimately, if a company cannot be revived or cannot be reorganized, the liquidation must be done swiftly so as to attain the most value from those assets. And that is why the second feature of this IBC, as reflected in the preamble, is the maximization of value of assets of such persons. So, RDDBFI Act, if we talk about now, that RDDBFI Act was again having a very limited scope, because firstly, yes, it established DRTs, it established DRATs, a specific forum for the first time was established for debt enforcement. But then again, that the application of that act was restricted to the banks and financial institutions only, and the other creditors such as trade creditors or the workmen of the company, employees of the companies who are also one of the stakeholders in an organization, they all are not having any rights under the RDDB-FI Act. Therefore, that particular act also fell short in addressing all of the problems, because it did not focused on reviving a company, but but in establishing a debt enforcement procedure for the banks and financial institutions. The preamble of this, the Recovery of Debts and Bankruptcy Act, which is the later name of this act, goes like an act to provide for the establishment of tribunals for expeditious adjudication and recovery of debts due to banks and financial institutions. Then, this particular part, insolvency resolution and bankruptcy of individuals and partnership firms, which was added later on, if we see, instituted by Act 31 of 2016. which is the Insolvency and Bankruptcy Code. So before the Insolvency and Bankruptcy Code came into force, this act only focused on recovery of debts due to banks and financial institutions and for matters connected therewith or incidental thereto. Similarly, if we go on to the preamble of SURFACI Act, this is an act to regulate securitization and reconstruction of financial assets and enforcement of security interest and to provide for a central database of security interests created on property rights and for matters connected therewith or incidental thereto. So this act also did not focus on revival of a company or an organization or reorganizing of assets or liabilities of an organization in any manner. These two legislation focused primarily on the recovery of the debt and the scope of these two acts. RDDB-FI Act was applicable for the banks and financial institutions, but SURFACI further limits the scope and it creates a separate category that is the secured creditors, and this act was only available to the secured creditors. So all these three legislations, where they fall short and why the need of creating a consolidated insolvency and bankruptcy code was felt because there was multiplicity of laws, and under these three acts there was different multiple forums which a creditor could focus on. And one such example, if we see, was the case of BHEL versus Arunachalam Sugar Mills. Now this case was decided by Madras High Court in 2011, and it provides a very good example that what all options a creditor has to uh, enforce its debt. Now, in this proceedings, a very unique situation arose. So, these are the pointers which were specifically noted that how these proceedings came into being one after the other. So, a bank, the main secured creditor, he filed an application in the DRT for debt recovery. Another creditor filed a company petition for winding up. Another secured creditor that had lent funds to ASM through a credit facility entered into an MOU with the bank for the bank to sell the debtor's properties and pay the secured creditors its due from the proceeds. Then a company that had leased machinery to ASM initiated proceedings invoking the arbitration clause and moreover filed an application in the High Court restraining the ASM from transferring or selling its assets. Then a secured creditor of ASM's sister concern initiated proceeding under SURFACI Act, took possession of its assets and sold the same by auction. Moreover, an unsecured creditor which had supplied a boiler to ASM filed civil suit against ASM for recovery of money due to it by sale of immovable properties of ASM. So this case is a very unique setup where we can have a taste of all the creditors, being it secured, unsecured, and we can see how the creditors are approaching different forums. So now to take one by one, SEC Industrial Companies Act, the procedure under Second Industrial Companies Act, though the act aimed to revive and reorganize the uh, in an industrial unit who has gone insolvent, the procedure was that the creditor used to make reference to the board, and then the board used to assess the viability of the business of that particular industrial unit, and thereafter the matter was referred ultimately to High Court for winding up or for liquidation, or if an reorganization scheme is possible, then that to implement in the implementation of that reorganization scheme, another 4 to 5 years used to go by. So that is why to safeguard the interest of the banks, particularly banks and financial institutions, because we are talking about the year 1985 here. And in the year 1990, LPG came forward. The LPG policy of Government of India came forward. Thereafter, the need was again felt to secure the banks and financial institutions first and not the other creditors. Therefore, the government deemed fit to enact the Recovery of Dues to Banks and Financial Institutions Act in the year 1993. Now, RDDBFI Act provided a simple procedure to file a recovery claim before the DRT, but under the RDDBFI Act also, that once you file a claim before the DRT, that DRT claim was adjudicated. It used to take another 2, 3 years, and thereafter, then the appeal lies to the DRAT. Then from DRAT, a company can go to High Court, then to Supreme Court. So ultimately, the result, so many years used to go by that the result becomes nearly zero. Because as we have also discussed, the time-bound manner concept, which is very essential. So many years in the litigation, so the value of the asset is bound to erode and the recoverable value becomes nearly zero for a creditor. Then the model which these two laws follow, Sikh Industrial Companies Act and the RDDBFI Act, is the debtor in possession model. Now, what is this debtor in possession model? So when we talk about debtor in possession, it means that once a company goes insolvent or bankrupt and a reference is made to the board under the SICA Act, or a claim is filed under the RDDB-FI Act, there was no impediment on the debtor to use its assets. And in simple words, the debtor was free to handle its assets on its own, and the creditor would not be having any right on the assets of the debtor unless and until the matter is finally decided by the board under SICA or by the DRT under RDDB FI. Yes, there were interim stays, but still that did not preclude debtors from dealing their assets, and they were successful in siphoning off their assets to other third parties and to safeguard them from the insolvency or liquidation proceedings. So, as long as the debtor was in possession of its assets and is free to handle its assets on his own, there is no material proceedings. Material, by the word material, I mean the proceedings under SICA or the RDDBFI Act would not be having any material effect, because the debtor, while the proceedings are going on, they used to sell off their assets or they used to run away to some other country and ultimately to safeguard themselves from the insolvency and liquidation proceedings. So the debtor in possession concept is one of the concept where these two act falls short. And to address this issue for the first time, when the SURFACE was enacted, we can see under Section 13 of the SURFACE, particularly that this debtor in possession model was, for the first time in India, was converted into creditor in possession. Now, if we come to Section 13 of SURFACE Act, just a minute. Yes. So this Section 13 of the SURFACE Act is the core section of the SURFACE proceedings. Now, this act, when we go under that, we can directly move forward to 13.4. So, in case the borrower fails to discharge his liability in full within the period specified in subsection 2, subsection 2 is basically a notice which is to be sent to the borrower by the secured creditor. The secured creditor may take recourse to one or more of the following measures to recover his debt, namely take possession of the secured assets of the borrower, including the right to transfer by way of lease, assignment, or sale for realizing the secured asset. Take over the management of the business of the borrower, including the right to transfer by way of lease, assignment, or sale for realizing the secured asset. So here in the SARFAESI legislation, for the first time we see that a creditor in possession order is being followed. But then again, this SARFAESI legislation was firstly criticized because Section 13 of this SARFAESI legislation provided a direct approach to the creditor that, okay, boss, you go, you send a notice to the borrower. If the borrower does not reply within that time or fails to discharge his liability, you can directly take possession without recourse to a tribunal or a court. And on this premise, this SARFAESI legislation was challenged. Its constitutional validity was also challenged. That it being a draconian law, it should be struck down because there is no involvement of any court, and the secured creditors are given very arbitrary and very wide powers. However, the Delhi High Court in Mardia Chemicals case, and then which was later on got transferred to the Supreme Court. So ultimately, the Supreme Court in the Mardia chemical case upheld the validity of this SARFAESI legislation and observed that Section 13 is not violative of any of the provisions of the Constitution, and the secured creditors can very well take possession of the secured assets if the borrower fails to discharge his liability within the given period of time. So, a bit of a evolution of insolvency laws which we can see here is that from SICA to SARFAESI, there was a change in the debtor in possession model to creditor in possession model. And why is it important that the creditors have the control over the assets and management of the debtor? Is because to preserve the value of those assets. If the debtor is having the possession of its assets even after it has been declared insolvent, the debtor will definitely try to either save himself by selling off those assets or by transferring it to some other organization. And ultimately, the interest of the creditor is lost. Now, what other problems these three legislation faced was the conflicts over jurisdiction, which means these three acts were having non-obstante clause, overriding clause, and the clauses where the jurisdiction of the civil court was ousted. But if we see in cadena of judgments between different high courts or supreme courts, we can easily determine that despite there being non-obstante clause and overriding clause in all these three legislation, there were many a times conflict between the applicability of these laws. Because if there are two creditors, two banks of a single company, and one bank goes under SICA, file a reference to the Board for Industrial and Financial Reconstruction, and the other creditor goes for an action under SARFAESI, then there will be overlapping of the proceedings, that which act should prevail over which act. Now, in a few judgments, the Supreme Court have taken the stance that the purpose of SICA, which is to ultimately revive and reorganize the organization or the industrial unit, should prevail over the objectives of SARFAESI because the SARFAESI legislation is limited to the recovery aspect only. But then again, also in another set of judgments, the court was of the view that which is the normal course of interpretation or a very normal rule of statutes of interpretation of statutes, was that the SARFAESI Act being a legislation enacted in a later point of time, it should prevail over the earlier legislation. Because when a legislature enact a law at a later point of time, it takes into consideration all the previous laws and then only it enacts the future law. And that is why the SURFACI Act should prevail over the SICA. Similarly, there were conflicts between RDDBFI Act and SURFACI Act because RDDBFI Act mandated the bank or a financial institution to approach the DRT for recovery, whereas under SURFACI, the secured creditors, maybe a bank or a financial institution, they are free to take the possession of the asset by serving a notice upon the borrower. So few creditors are approaching DRT under RDDBFI, whereas few creditors are approaching DRT under SURFACI. And then again, the issue of overlapping jurisdictions are arising one case after the other. So this existence of multiple forums was one of the major problems that the earlier insolvency and bankruptcy laws of India could not resolve. And that is why all these ideas which we see in the preamble of the Insolvency and Bankruptcy Code, these ideas are basically the solution to all these problems or the premise of the solutions which the Insolvency and Bankruptcy Code has now put forward, that there will be only one NCLT, one adjudicating authority, which will oversee the insolvency resolution proceedings of a company, and there will be uh, no other court or a tribunal which will be having any sort of jurisdiction over the insolvency proceedings. So these particular legislations and the problems in these legislations are the reason why the this unified insolvency and bankruptcy code was enacted. And to basically to address these problems, the Insolvency and Bankruptcy Code is in itself established a whole set of framework, which we can also see moving forward if we read the preamble, including alteration in the order of priority of payment of government dues and to establish an Insolvency and Bankruptcy Board of India and for matters connected therewith or incidental thereto. So, an Insolvency and Bankruptcy Board of India was established by the Insolvency and Bankruptcy Code. Now, this particular board was tasked with multiple responsibilities. That is to maintain the record of each and every insolvency proceedings, to be a regulatory authority for the insolvency professionals and though insolvency professionals who later on act as a liquidator. So to create a proper framework that there should not be any delays in the proceedings, this Insolvency and Bankruptcy Code has established an Insolvency and Bankruptcy Board of India. So this was one of the development of the Insolvency and Bankruptcy Code in bankruptcy laws, that earlier insolvency and bankruptcy laws used to follow debtor in possession model, which may also be known as pro debtor stance model, and later on by the time this model was converted into a creditor in possession model, where the creditors can have control over the assets and management of the debtor and to preserve their value so that they can get the maximum output from those assets and they can recover their money to a maximum possible extent. Now, the other one of the other concepts which may also be understood to understand how these insolvency and bankruptcy laws has developed was there are proceedings in personam and there are proceedings in rem. Now, proceedings in personam means that a particular person is having a claim or a right exercisable against only one person or a particular set of persons. Whereas proceeding in rem means that the person who is filing those proceedings or who is exercising his right is having claim against the whole world, whosoever is affected by the exercise of such right. So when we talked initially about the remedies available to a creditor, for such as uh, approaching a civil court for recovery claim, then filing a recovery claim before DRT under the RDDBFI Act, or taking possession of the assets of the debtor under SURFACE, and filing a reference to the Board for Industrial and Financial Reconstruction, or for filing winding up or liquidation proceedings under the High Court. So what we need to understand is that filing a recovery claim before the civil court, or DRT under the RDDBFI Act, or taking possession of the asset under SURFACE, these proceedings are proceedings in persona. Why? Because there are only limited parties involved in these proceedings. So when a bank approaches a DRT for a money claim, so there is only that bank and the debtor which will be involved in that proceedings, and there will be no consideration whatsoever of the other creditors which may be there and which may also be having their own claims. Therefore, these proceeding in REMS usually overlapped with each other, because when there are different creditors and they are approaching, let's say, same term only. There are three bank creditors of a company, and those three banks approach the DRT under RDDBFI only, but the adjudication of their claims will be separate. And there may be an instance that those three proceedings may be consolidated by the DRT, but it may not do so if the claim of the other bank is under SURFACE, or for that matter, a bank has directly gone for liquidation or winding up of that particular company. So, when a claim is being filed under DRT, the DRT will be adjudicating that claim um only upon the only upon the contract which is there between the two parties, and it will not give any consideration to the claim of the other creditor. So if a company goes bankrupt and the company is only having the assets worth rupees 10 crores, but the debt which may be owed to different companies may be 50 crores, and one of the creditors goes and file a claim for 20 crores, and the DRT adjudicates its claim in full and gives him the permission to, okay, you go ahead and recover the 10 crore assets of this company. The rights of the other creditors are not taken care of. Whereas when we come to the preamble of the Insolvency and Bankruptcy Code, the phrase balance the interest of all stakeholders, which means that all the stakeholders should get a right of being heard when a company is getting insolvent or is any liquidation proceeding is going on, and all the creditors should be able to recover something. If not all of their claims, they should be able to recover something, and that should also happen in a proportionate manner. So, therefore, the evolution of these insolvency and bankruptcy laws from proceedings in personam to proceedings in rem can also be seen with the enactment of the Insolvency and Bankruptcy Code. And this evolution of the insolvency and bankruptcy laws is also very much important, because the rights of each and every creditor matters. And if we see the framework of IBC, it does not only covers the banks, it covers all the other financial creditors as well. And moreover, it has also categorized the trade creditors as operational creditors, and also has given them a right to be heard in the insolvency proceedings and to file their claims for recovery of money. Even though there has been some disputes about the rights of the operational creditors, and there being very less say of uh, let's say, granted to the operational creditors in these proceedings, still the IBC recognized the rights of each and every stakeholder of an organization. So when we go from CICA to RDDBFI to SURFACE, we can see that the understanding which has been built, which has been observed in the uh, development of insolvency and bankruptcy code was that the proceedings, the insolvency proceeding should be in REM, and all the stakeholders which are there of a company should be invited, should be informed to come forward and to file their claims. And later on, when the ultimate decision is being taken, the due consideration to all the claims should be given. So this is these are some of the examples which we can see, and we can understand how the insolvency and bankruptcy code came into being. And to better understand the enactment of insolvency and bankruptcy code, I would refer to you that you may go through the committee report of the Bankruptcy Law Reforms Committee 2015, which is divided into two reports. One is interim report of the BLRC and the final report of the BLRC, through which committee report this particular IBC was enacted. The reasoning of enactment of IBC, the problems in SICA, the problems in RDDBFI, the problems in SURFACE legislation was highlighted, and the latest framework which is now being followed, establishment of a separate regulatory authority known as the IBBI, why it was necessary and how it was done, was everything you can find in those two reports, and you can increase your understanding as to why this particular IBC was necessary and why the repeal of SICA was necessary and why the insolvency proceedings, the core of insolvency proceedings, that why is it necessary to involve all the stakeholders and why is it necessary to see insolvency law as a method not only of debt enforcement but to revive a business of a company, of an organization. Because if we see insolvency or bankruptcy law with a point of view of only debt recovery, then there will be no per se development of the overall market economy. And the development of overall market economy can be achieved only when the insolvency law is aiming to revive a company or revive a debtor. Now, reviving a company or reviving a debtor does not mean that you give that particular debtor a second chance to run its business. Obviously, a debtor has defaulted on its loan. He has not been able to carry out its business operation with much efficiency. Therefore, the company went into insolvency and bankruptcy. So, it does not mean that you give the same debtor a second chance, but the idea is to save the particular business, because with each business, a lot many ideas are also created, innovations are made, and to protect those innovations and to keep the business going, to keep the market economy stable, the idea behind insolvency procedure is that to revive that particular business, to reorganize the assets and liabilities of that business so that those innovations, those business activities may go forward, and some other person may come into picture, take over the business of that company and carry forward the business in order to promote overall market economy, to promote overall entrepreneurship, which is again, which we can see in the objective clause of the IBC, that to promote entrepreneurship. And then the BLRC also reflects upon the idea of availability of credit, which we can also see in the preamble clause of the IBC. So the BLRC has also noted that the businesses, the young entrepreneurs which are now coming forward, the idea of startups, MSMEs, and government being very liberal in granting loan schemes to these entrepreneurs, is that the market is right now being flooded with new ideas, new possibilities, new opportunities. And there may not be every person may not be having so much of resources to establish a full-fledged business. There, that is why the availability of credit in the market is very essential. And if a bank per se is facing defaults after defaults by the debtors, then ultimately that particular bank will in future will go bankrupt and there will be no money to lend to these young entrepreneurs. Therefore, the idea to protect banks, which was reflected in the enactment of RDDBFI and SARFAESI legislation, was that only to protect the market economy, that the banks should always be there to finance these businesses. But later on, now the time we have seen that there are not only banks and financial institutions which are into the which plays an essential role in running of the business, but there are also other creditors whose interests are as equally as important of the bank. So therefore, the this insolvency law aims to protect the rights of all the stakeholders, and this insolvency law is not only focused on uh, protecting the claims of the banks and to promote the banks, but other creditors also who are operational creditors, who are trade creditors, because those trade creditors are also the entrepreneurs and their protection is also necessary to maintain a balance in the economy. So that is why this insolvency and bankruptcy code focuses on the rights of all the stakeholders, and it focuses on establishing a single forum where all these creditors can come together and address the issues of insolvency and put in their efforts to revive the business of an insolvent organization. Whereas if we see uh, Sika was also having the same objective, the reorganization or reviving of an industrial unit. But then again, Sika, the scope of Sika was very limited to industrial units, and the framework which the Sika was following, that first a reference to BAFR, then winding up by the High Court, then it was occupied with the natural delays. Likewise, RDDBFI and surface legislation also, these these two legislations are also short in addressing the claims of all the other creditors, safeguarding only banks. But even if the uh, even if these acts are safeguarding the rights of the banks, even in that eventuality also, these acts were not so effective because the judicial mechanism, the natural delays which are always there, used to occupy these legislation and the ultimately the time value of the assets. That aspect comes into picture and the effectiveness goes to nearly zero. So these insolvency and bankruptcy laws has taken a very rough journey or very big journey from SICA 1985 to IBC 2016. And now the IBC Code 2016 is focused on resolution of the corporate debtor. Yes, the IBC right now per se is not applicable to partnership firms and the individuals, even though the Part 3 contains the provisions. It is applicable only to corporate debtors right now. But still, the enactment of IBC with a very wide view can be seen from the perusal of the preamble itself. So I think for today's session, it is uh, the SICA and RDDBFI and SURFACE, the overview of these legislations are enough. In the next session, I will be dealing with the BLRC's final report, and we'll be looking into the aspects which the BLRC's has considered in enacting the IBC legislation, and also how the BLRC has established a efficacious framework, the establishment of IBBI, why it was necessary, and what are the implications. And also, we'll be having a look in the past, almost now it'll 8 years, more than 8 years of the IBC, how the IBC has been effective, and where are some shortcomings of the IBC in comparison to the BLRC vision, whether these the problems which are being faced uh, now with the IBC, as though are those problems uh, addressable, or there is a need for enactment or amendment in the IBC also. So thank you very much for joining today's session. I hope you all learned something today. So thank you very much. We'll see you in the next session.